Thank you for attending and staying to the last session. Presumably throw rotten eggs at me, because I'm a lawyer. No hard feelings about the fees. I'm a solicitor at Mills Reeve, and I lead the firm. It's a national firm, and I lead the firm's technology group in the Midlands. As the chairman accurately said, I'm a digital and data lawyer. I'm not a criminal lawyer, but I'm adopting the judge's mantle for the day and swapping it for the commercial suit and speaking to you on the accidental criminal common security laws you could be breaking. It's a world of opportunity out there, and I'm not going to go back over that. Those of you that have seen the earlier presentations, I'm sure that you've been appraised of all of the opportunities that criminals out there have in order to commit their crimes, to gain control of your devices and your applications. What we're going to focus on are a handful of crimes that I think are likely to be committed by organisations or their people, which tends to be my focus as a practitioner. There are lots of civil laws around this as well, and we'll touch on some of them, but it's intended to be quite a light touch, informative, particularly with some helpful pieces of advice towards the end when we wrap up. But I'm not wanting to overstretch you, and it's certainly not a legal lecture, so please hang in there. So let's look at the first offence. Hacking, which is a really general term, isn't it? It just refers to doing something unwanted with a device or a network. But what does the law mean by hacking, and how do you go about committing the offence? Well, there are actually two offences, and we'll have a really quick look at them one by one. And the first one is accessing a device or a network. So what's your aim as a hacker? Your aim is to get access to any program or data in a computer. Computer means network as well, a network of computers. Why is it banned? Well, you're not allowed, you're prohibited, or in particular, you're not authorized to access the computer or the network. And how do you do it? What's your modus operandi as a criminal in this situation? Well, you get the computer to perform any function. Now, that's really important because it means you can just set it up to do something that is without authorization and leave it to do it. It doesn't have to be you pressing the buttons. You don't have to be present. You just set it in motion. How about other related naughtinesses? Well, you can often gain access to a computer system or a network, not just with the intention of rubbing your hands and saying, I did it, but with the intention of committing another criminal act while you're there. So maybe it's a fraud. Maybe you're hacking into a computer in order to mess about with the finance system and the records within the finance system. You can see where this is going to end up, can't you? But for the time being, perhaps in the public imagination, when we talk about hacking, the typical notion that we have is of a teenager who's maybe UFO obsessed, and they're hacking into US government systems to try and find out all that they can about UFOs. Hacking is done by other people, isn't it? And it's broadsheet news or national newspaper news. So let's think about the other offence, because I mentioned there are two. We've thought about access, but there's a broader offence, which is broadly unauthorised acts relating to computers. What's your aim if you want to commit this offence? Well, your aim is to carry out an act that's unauthorised. You don't have permission to do it in relation to a computer or network. It's really broad language, isn't it? You have to have intent, you have to mean to do something that's criminal, that's an offence, or you have to be reckless. That means you don't care about the outcome. You don't care about the consequences. Or you know what they are, but you don't mind about them happening because somebody else is going to suffer them. Why is it banned? Well, again, it's because you don't have permission. It's because you're not authorised. That's always the concern with criminal law in this area. And how do you do it? Well, you impair a computer's operation. You stop it from working the way that it should. You prevent or hinder other people's access or other computers' access to a program or the data within those systems. or you impair the way that computers or data or programs operating on them operate, or their reliability. Even enabling that kind of thing to be done is also an offence. So let's think about some examples. Let's make it concrete again. How do you commit this hacking offence? Well, I think if we concentrate on on the newspaper concept of hacking, it's going to be writing a virus. That's enabling something or someone to impair a computer's operation or prevent or hinder a program from operating. Or carrying out a denial of service attack. Have you heard about denial of service attacks earlier in the day, or you're otherwise familiar with them? It's basically overloading a computer or a network so that it gets into a position where it can't talk to you, it can't do its normal business. You might do that in order to make it insecure, or you might do it just for the fun of it. That would be impairing the computer's operation, so it would actually be an offence. And being involved in performing a ransomware attack as well would involve preventing or hindering access to any data that's held in a computer or a network. It's a crime. All of these crimes, if you're interested, are set out in the Computer Misuse Act, which is old legislation now. It was passed in 1990, although it's been updated from time to time ever since. So I've given you some examples, maybe from the public imagination, but let's bring it closer to home now. Because actually, these offences aren't just committed by other people who are out there. It's not just the organised criminal gangs or the teenagers, the obsessive teenagers. Sure, it's them, and they're a major risk. But a very, very significant source of cybersecurity incidents is actually insider attacks, including insider ignorance and blundering. So let's think about a couple of case studies off the broadsheets, away from the newspapers. And the first one, take a look, as I've called it on the slide, is an example of the accessing with unauthorized accessing offence. You take a look without permission. Well, let me give you an example of somebody who was prosecuted for exactly that. It was a lady who worked in the insurance sector. She had a troubled past, like me, and many lawyers, and she'd broken up with her ex. But she knew who her ex was now with, and she knew that that person was a client of her employer. That person had taken out insurance with her employer. She had access to all of the insurer's records, and it was part of her job to access those records. It wasn't part of her job to look at those records for that person, but she thought she would. That is the offence of accessing without authorization. She was actually prosecuted under other laws because that was an easier prosecution. But you can see that she committed the offence of hacking as an administrative clerk. She's been prosecuted, she's got the criminal record to prove it. How about the other case study? And this brings it close to home. It's a matter that I personally advised on. I'm not going to give you any names, so I'm not breaching any confidences, but this is close to home for me. Now we're looking at the other offence of just carrying out unauthorised acts relating to computers and computer systems and data. This case study involved an IT manager who was responsible for the security of a network that he looked after. He briefly but deliberately exposed that network to the outside world so that its normal security measures weren't operating. He was a trusted member of staff, operating with a clear job description, but he wasn't sufficiently managed and monitored, and he went ahead and did it because he had the opportunity. He worked for a national organisation, and he was responsible for one site within that organisation. He took it down, the site was infected, the network, and I mean the network, all of the hardware was irreparably damaged so that it couldn't be recovered, it had to be replaced, along with the applications that were running on it and the data that was stored on it. The whole lot lost. he was prosecuted, and I'm afraid I can't finish the salacious story. I don't know the outcome, but you can pretty much bet your bottom dollar he's now got a criminal record, or he's looking down the barrel of it. These criminal offences can actually be committed by people within your organisation, and that's why you've got a commercial lawyer who advises organisations standing in front of you and talking about crimes. I need to worry about them as a commercial lawyer, and you do as well as commercial and operational people. Before I go on to the next criminal offences, I need to just give you a little bit of a 101, a reminder about personal data. You probably did it to death in 2017 and 2018 because everybody was jawing at you about GDPR. Yeah? No? Probably. You're probably still scarred from the experience, so you're not prepared either to shake your head or nod. So what is GDPR all about? What's data protection all about? Personal data. It's information relating to living individuals who can be identified from that data. Hold that thought. What are we meant to do as organisations in relation to personal data, and particularly in terms of the security of the personal data? Well, the laws set a pretty simple standard that we must all meet. We have to implement appropriate technical and organisational measures. That means computer measures and ways of managing people and culture in order to ensure a level of security that is appropriate to the risk. And the legislation doesn't leave it there. It gives us some examples of the kinds of things we should be thinking about. So what I'm saying to you really is, you can't afford to ignore these things because the law puts them in the spotlight. Number one, pseudonymization. Stupid word, sounds long and complicated. It's a really simple concept. I told you that personal data is information about people who can be identified, and that's why it's personal. We're concentrating on the personal bit. Pseudonymized data, it's personal data, but you've taken the personal bits out. You've changed the data so you can't identify the people that it relates to anymore. You do it temporarily and just to make sure that it's secure in situ while it's at rest. It's a really simple but effective measure. There's another measure called anonymization, and you can guess, anonymized, anonymous. It's to do with just blanking the data. It's not a temporary measure. You remove the identifiers so you can never again identify the people that the data relates to. And there are some other concepts there that will no doubt be more familiar to you as well. Encryption, sure. The ability to ensure that the systems and the data on the systems are reasonably secure and available. The ability to restore availability if you lose it. Yeah, business continuity is a legal consideration these days, and regular testing. Don't just build the system, don't just design the system, but check it out as well and make sure it works in an emergency. So I want you particularly to hold that thought about anonymization because it's so important when we think about the data protection crimes. What are they? Well, I'm actually going to start with the second one in the list because I've just prepped you about it. It is a crime to re-identify data once it's been anonymized. I think it's potentially a crime to re-identify data when it's sitting around in pseudonymized state, that temporary anonymized state. This is really important because if you commit this crime, what you're doing is trying to break your organization's security measures. They've pseudonymized, you're reversing it because you want personal data. They've anonymized the data. You re-identify it in order to break that security measure. It's not just a crime against the organization, it's a crime against the people that the data relates to, because they are probably trusting your organization to keep that data safe. That's why it's a crime and things get personal. What about the first bullet point, the hand in the till? Well, that's kind of what the insurance lady did in the example that I gave you. But there's a little bit more to the criminal offence. It's got two bits. The offence is committed if you obtain personal data unlawfully. So if you've got access to it and you enjoy that access without permission, It's also committed if you disclose personal data without permission. So just sharing a little bit of your organization's personal data with a friend or member of the family in order to help them to establish a business, that's a common one, or to introduce them to people. The offence of obtaining personal data or disclosing or even procuring the disclosure of personal data, they're all criminal offences, as is retaining personal data for longer than you should. If you do that knowingly, or you do it without caring about the consequences, you or another person in your organisation has committed a criminal act. Now, these are red lines, and it's not necessarily just an offence that's committed by the person who's got their hand in the till or who re-identifies the data. It's an offence that can be committed by the organisation, corporately, and then it kind of smears down the chain of command. This is an offence that can be committed by senior managers who were negligent. They could have done something, but they failed to. They connived, they were in on it, or they were reckless. They couldn't care less. Negligence, connivance, or recklessness wins you as a senior manager or owner of the business exactly the same criminal offence liability. You can see how the hacking offences are always personal. It always requires somebody to be doing the doing in the case of those offences. With these ones, under the data protection laws, they're actually corporate offences, but they can smear senior managers as well as the individuals who commit them as well. It's an awfully fraught area of crime and practice. What's the consequence? Criminal record and fines. But let's start to edge now into the civil consequences as well, and these have been well rehearsed by the GDPR pundits, so you might already know quite a lot about them. I'll just run down the list here. So you have criminal records, that very personal impact to be concerned about, but also administrative fines for eye-watering amounts of up to 4% of your global turnover across the group, if you're a group organisation, or 20 million euros, which plays out at about 17-point-something million pounds sterling. Compensation claims by data subjects, people that the personal data relates to. More about that in a minute. I'll give you another case study. Supply chain claims, they suffer liability, so they sue you to recover their loss in terms of your suppliers and your contractors and subcontractors. Reputational damage, which apart from the direct financial loss, is probably a biggie. It's not a legal risk, is it? It's just a straight down the line commercial risk. If you commit these offences, if you damage your reputation in terms of being able to maintain good cybersecurity or being able to maintain decent data security, you affect the relationship of trust that exists between your organisation and your customers and your organisation and the supply chains it operates in. That's potentially the end of your organisation. That's the effect of reputational damage. Data subject complaints, which are bothersome and costly to deal with, but probably not the main risk you need to worry about, and regulator action, which falls into the same bracket, but believe you me, you don't want either of those two things to be happening to you. So let me give you the case study, and this is about data subject compensation claims. And this is how a crime can get really nasty in terms of civil law liability. I break no confidences by saying this relates to Morrison's supermarket. They had an employee who had a grudge. He was a senior employee. I see some nods of people that are familiar with the case study. It's well reported. It's gone through the courts, although there's the Supreme Court still to go. So watch this space in terms of what happens to this man. He was a senior IT manager within Morrison's, and he had access to the entire payroll database. As he had a grudge, obviously it was appropriate for him to expose the entire payroll database to the world. So he did. That was a crime, and you can see why in terms of hacking offences and data protection offences. It had crime written all over it. But the civil consequences were severe because Morrison's, as the employer, was held to be liable on his behalf for his acts. The employees of Morrisons as a group are suing Morrisons, each for a basic level of compensation. But if you take several 100,000 employees, each claiming a basic level of compensation, you have a compensation claim for several £100 million. It was bad for the IT manager, but you see how it's horrendous for the organisation as well. And don't we want to protect our staff from stepping over these red lines? Hopefully we do. There are other horrendous civil consequences that I won't bore you with. If you are a regulated organisation that is subject to the Network and Information Systems laws, specific cybersecurity laws, you should know about it already. You needed to know in November, actually. But let's not cry over spilt milk. If you're not sure, grab me or contact me using the contact details on the presentation. I'll be happy to give you a steer. It's kind of outside of the scope of what I'm doing this afternoon for you, but you can see the figures. They're pretty scary. £2 million here, £500,000 there, up to 17 million quid again, and yes, double jeopardy applies. So you can be liable for these amounts under cybersecurity laws as a result of a criminal act, as well as being liable under data protection legislation, and as well as being exposed to data subject compensation claims. Ow. It's important not to lose sight of the other crown jewels as well. I don't want you to be over-focused on monetary liability or the criminal liability. What about the practical assets that can get damaged by a cybersecurity breach? It's your IPRs, your intellectual property rights, your know-how. That can be, for many organisations, particularly digital organisations, your crown jewels. Confidential information, yours and other people's. Your ability to operate, and information that is the crown jewels of your customers, your staff, and your supply chain participants. So there's plenty to worry about. How do we deal with it? And here are the top tips that I promised at the beginning of the session. I see it as being a compliance triangle. And this is how you try to manage your risks within the organisation. If you take one of the points out of this triangle or one of the sides off it, you've got a broken system that isn't going to do what you want. Firstly, you need leadership. And in some cases, the law actually says, thou shalt appoint a leader in your organisation to be responsible for security. Sometimes that is mandatory by law. If you've got questions about that, ask later. But, you know, even if it's not legally mandatory, this is an area that's complicated and requires leadership. So make sure that you have leaders in place that know what they need to know in order to provide leadership. Next, you need policy and procedure. You need to communicate these red lines to your people. Tell your suppliers and your staff what you expect of them and what they must never do, and tell them the reasons why. You need written policy that is tailored to your organisation, not grabbed off a shelf. And you need to train your staff on your policy and procedures as well. Finally, the final corner in the triangle, you need business intelligence. Don't just tell them what they need to know. Check if they understand it and if they're complying. Now, this is really difficult, and it's the one thing that I think organisations tend to fail on. I see a lot of organisations that have good leaders, a lot of organisations that really sweated over their policy and procedures, but they really struggle with the monitoring arrangements and making sure that they have good business intelligence. If you don't have the good business intelligence, if you're not finding the signs of cybersecurity incidents occurring, you're not going to be able to take appropriate steps to manage those risks. What I've outlined for you here, and the slides will be available afterwards so you can look at the grayed out bits at your leisure. It's the outline of a good incident handling procedure. So if you've got a cybersecurity incident or a specific data incident, these are the 4 steps you should be running through. So once you've found out about it, you need to contain the data, get control of it again, assess the ongoing risks, notify people like your regulators, work out what you need to do to stop a recurrence, and do that. But none of those steps 1 to 4 ever happens unless you achieve step 0, discovery. Business intelligence is such an important part of your compliance triangle. So, in conclusion, what are we protecting? Well, we're protecting our people. We're protecting our crown jewels, our information assets, and the crown jewels of our customers and our supply chains as well. What are the real risks in terms of cyber security? Well, yes, there is significant organized crime that is orchestrated by governments and via the dark web that we know about. But there's a major, major risk in the form of insiders, either acting deliberately or blundering around for want of good guidance and management. We're worried about networks as well as data. We're worried about continuity as well as security. You saw the emphasis that modern legislation places on continuity of systems and continuous availability of our data. It's key now. And if you are subject to those special cybersecurity laws, they place a special emphasis on cybersecurity and system availability and continuity too. But what's the real learning point? Well, the point that I've really emphasized for you is the importance of policy, the importance of telling people what's in the policy and giving them appropriate training and making sure that they're aware, not just within your own organization, but within those supply chains that you work with. The importance of culture. It's not something that I singled out when I was going through the individual points, but culture is key. You need to engineer a culture within your organization where people feel able to notify your leaders of cybersecurity incidents without fear of blame. You know, if they're committing a crime, they're going to be not wanting to blow the whistle, but for everybody else, you need to make it easy for them to report so that you pile up that business intelligence. And crucially, the importance of monitoring and review and feeding that with good business intelligence. And above all else, lead it or forget it. I hope that's been helpful. Thank you ever so much for your attention. And thank you for not throwing rotten fruit at me. Any questions?
Any questions from the floor, guys, at all? Gentleman at the back there.
Hi.
Hi.
Can you hear me okay?
I can't at the moment, actually. Thank you, Bob.
Can you hear me now?
Yeah.
Yes. You mentioned earlier on in your presentation about the law being updated on a regular basis.
Yeah.
How does the law see, or the penalties of the law, see from somebody actually entering unauthorised into somebody's premises and taking, for example, £300 versus a ransomware taking £300? Does the law see them both of those acts as the same weighting, or?
Yeah. Kind of, yes. There are different laws that apply. Firstly, in terms of the updating of law, is a really important and interesting point that you raised. Well, interesting for a lawyer, cue rotten fruit again. What tends to happen, because the law is written and because it has to be interpreted by idiots like me, it's normally out of date. So you tend to get legislation that is drawn really broadly in order to try and catch a broad range of offences, but without being too unfair, being too smudgy and broad brush. Many of the offences that we're talking about are actually really old. So I mentioned the Computer Misuse Act. That was introduced almost at the beginning of the personal computer era, certainly personal computers in organisations, 1990. So it's pretty well on the curve. It's been sort of incrementally updated since, but not much. I think the last significant update was in 2003. So it's kind of well-established law. In terms of breaking into premises, well, that would be the offence of entering without consent. And that's so old that probably the source of, I'm not a criminal lawyer, probably the source of law is ancient, before the 20th century. And the offence of theft. Some of these are only relatively recently codified by legislation. So the quick answer to your question is, yeah, these are criminal offences. Entering somebody's premises and taking something, if you do actually take something, that would be theft. Entering somebody's premises without consent, that's not necessarily an offence. it can be a civil matter, that's trespass. But if you actually commit an offence while you're on the premises, like burglary, for example, or another theft, definitely a criminal offence. And it's important for us to consider these old world offences to be relevant, because of course it's just as much of a cybersecurity breach if we've got an insecure removable hard drive or USB stick lying around in the premises and somebody just swifts them. Like I've got this beautiful Microsoft Touch pen. That looks like it's from a Surface. I will leave it there because somebody must want it. Those old-fashioned offences are equally relevant, but I've not headlined them because we're talking about the electronic sphere today.
Brilliant. Thanks, David. Any other questions? Oh, another one from the lady down here, if we could get a mic into there. Perfect, thank you.
Hello.
Hi.
Hi. I've got a question where we've got an insider threat, but it's not a deliberate one. When you do identify that that was not malicious and you've accidentally accessed something, or curiosity, because I do work in a social care environment where people often, if there is a flag or they've got concerns, they may access data. We've had instances where people have come back and said, I shouldn't have accessed it, but I have. HR-wise, we've given them a disciplinary warning. But how does this then work? Are we then doing enough by just giving them a warning because they've been upfront? We do have systems in place that would have the digital footprint that would show access of those records, but we don't necessarily go back and check each and every record because it's impractical to put access control on everything. So how are we then, are we doing anything about that? Or, I mean, is that enough? Or are we leaving a big gap open and relying completely on the honesty of the employees to come up and tell us?
Thank you so much for the question. What you've described sounds like a really appropriate procedure. So it sounds like you've got that magic culture, that gold dust culture where people feel able to self-report and don't feel that they're automatically going to be blamed. In terms of is it a crime, crime would require intent to actually commit an offence, an intent to act without authorization. So if somebody in their self-reporting has said, I really didn't mean to do it, hence putting my hands up, that tends to provide evidence that they didn't have the necessary intent and that they weren't reckless either, which, as you saw, is relevant for one of the offences. So at the first blush, for the first wrongdoing, I would say, there's limited evidence of an offence. If you get a repeat offender, though, it's at that point that you start to, look at your business intelligence, spot the pattern, and say, hang on, is somebody playing the system here? And are they doing it just on their own, or are they maybe syndicating within a group? And it's at that point, if you spot a trend, I would suggest you need to start taking further action. And that might be in the form of clearer policy, further training, maybe not just sticking at disciplinary, but involving outside agencies. Now, the police are not very quick to respond. Ditto action fraud, to be fair. Although I think an awful lot of the local force and what they're doing around cybersecurity and of action fraud, but they're overstretched. What you might want to do is work within the regulatory relationship with the Information Commissioner, particularly if it relates to personal data, and it sounds like it probably will in that sector, because you have carers and possibly clinicians accessing patients' and residents' data and service users' data. So more than likely personal data is involved, and you could legitimately refer the matter to the ICO. In some cases, they can put a case forward with a recommendation for prosecution to the Department for Public Prosecutions. So that would perhaps be your way forward if you're feeling that you need to tighten it up a little bit. But it's all down to your monitoring and looking at whether there's a pattern, seeing if your existing measures are working, and if not, try something different. Does that answer your question? Does it give you comfort? The
Brilliant.
answer was yes.
Thanks very much, David. Excellent.
My
Thank you
pleasure.
very much. Very interesting.